First of all, hello, everyone. Good afternoon, good day to all of you who joined us, and thanks for our panelists for joining us today. My name is Katharina Pistor. I am a law professor at Columbia Law School, but I'm also the president of WINIR, the organization that is hosting this panel. It is the World Interdisciplinary Network for Institutional Research and has been around for a number of years, was founded in 2013. David Gindis, whom you see on the screen as well, is the secretary of WINIR and the public relations officers. He's also a professor of economics at Hertfordshire in the UK, and will chime in the discussion as well because he has a deep interest in institutional economics or institutionalism more generally. Our two panelists who have been advertised when we sent out the notice are Amy Kapczynski and Nicholas Mercuro. Amy is a professor at Yale Law School, and as many of you know, she's really been a major mover and shaker behind the LPE movement. She co-founded the LPE blogs and is a co-faculty director of the LPE, the Law and Political Economy Project at Yale Law School. Again, as many of you know, this is now mushrooming and spiraling to other institutions, Columbia, Harvard, other institutions in North America, but also in Europe and Latin America, have started to explicitly create chapters, charters, associations, whatever, for LPE. So that's really an exciting movement. Nicholas Mercuro is a university professor at the State University of Michigan. He has degrees in economics and business administration and resource management. And he has contributed to a debate that has received less attention in the past, but actually speaks very much to the LPE movement on legal institutionalism or institutional legal institutions as an alternative to the Chicago-based law and economics for a very long time. And he will speak primarily also to issues of how economists should receive and think about LPE, but also how we might learn to do better than just trying to argue against Chicago and do more about this. So I don't want to take too much time up front. I wanted to give the speakers a chance to really talk about what they believe LPE is all about, where it has its intellectual origins from, what the aspirations of LPE are, and how we can make sure that we can achieve these aspirations. So I'm going to give the floor first to Amy. She will just launch into this, and then Nicholas will give his introductory comments. We will have a debate between the four of us for about 45 minutes, maybe up to an hour, depending on how excited we are going to get. But we also want to leave plenty of room for discussion later on. So if you have questions, please raise your hand. We will keep a tab on the participants list to see who has raised the hand first, and we'll just go in chronological order. Please be on note that the entire meeting will be recorded. So if you raise your hand and you speak, you will be recorded as well. If you're uncomfortable about this, you may just decide either to put a question in the chat and we'll try to get to this, or to email us later. So we don't want to suppress participation, but we also want to make sure that people have a chance to listen to the debate afterwards in its full extension. So Amy, please go ahead, and thanks for joining today, and I give you the floor to you.
Thanks so much for that lovely introduction, for organizing this conversation, which I've been really looking forward to. So as Katharina mentioned, I teach at Yale, and I co-run something called the Law and Political Economy Project and the Law and Political Economy blog. And I think one thing to say at the outset is that I see this as very much part of a kind of broader and organically evolving ecosystem that is trying to bring a renewed focus on law and political economy, predominantly to US law schools, although now there are law and political economy projects in Europe and certainly lots of interest in many other countries as well. But you'll see from the way I talk about where LPE has come from that it is, in the way that I think it's emerging and influenced in part by particularly US kinds of circumstances. That said, in an age of neoliberalism, the US is, and sort of high globalization, the US is not, of course, separate from the globe, but part of a dynamic set of global processes. So where is the law and political economy kind of movement or framework or kind of the desire to think anew about law and political economy coming from? I think the first place that I start in answering that question is with the political environment around us, right? So broadly, a sense, and I think in some ways that the origins of the LPE as a more organized group of people and sort of a more concerted attempt to bring back political economy is a result of things like Occupy, the rise of populism, the rise of recognition of wealth inequality, but also precarity of work, the deep persistence of racialized injustice and gender inequality, and a desire, I think, that you see in many different places in our politics to think again about the relationships between class and the structure of our economy and the challenges that we face so one is in this register of inequality, right? So the particular concentration of incomes at the very high end of the spectrum in most countries, actually, the racialized and gender inequality, the climate crisis, which connects, I think, quite deeply to some of the political economy questions that we're interested in. I think right now, in the midst of COVID, particularly in the United States, I also would put into the picture the decimation of our public institutions, the fact that we don't seem to have institutions that are capable of making our schools safe, of getting unemployment benefits to people in a reasonable way, and sort of that is having a sort of really sort of toxic interaction with our broader politics. And so, of course, our democratic institutions are also under threat. And I think people are feeling that they're more precarious than they have been, and that our democracy broadly is not representative, that many of what ordinary people want won't happen because of various kinds of elite capture. And of course, now the sort of new populism is very much on everyone's minds. I would say a kind of common denominator of sort of where LPE comes from, as I think about it, is that these forms of crises are interconnected, and that the way that legal thought has kind of operated over the last several decades, particularly thinking here in the US, has not set us up well to think about these crises, about where they come from, about their connections, and has not set us up well to address them. And often the way we talk about it and frame that, and so here I'll sort of might be useful to look at a paper that a number of us wrote in the Yale Law Journal about the law and political economy framework, is through the lens of neoliberalism. That neoliberalism as an idea, in a very simple way, of course, many people think of it as the attempt to free the market and roll the state back. I think historians of neoliberalism have made it quite clear that that's actually not the right way to think about it, that the project of neoliberalism is as much about rolling the state out in certain kinds of ways as rolling it back. And so you protect investors, for example, against local laws related to, say, overriding patents or setting minimum wage. So you're protecting a certain kind of class, capital, from what you might call more democratic impulses to redistribute. And you're also building out certain kinds of state capacity to militarize borders. In the United States, of course, the carceral state and prisons are a big part of what we get in the neoliberal age. So the neoliberalism as a kind of epoch, as the new form of capitalism under which we're living, has worked its way into law and into legal ideas. And so we are trying to sort of trace how that has happened. And in some sense, this is has a generational flavor. Not everyone involved in LPE is of a particular generation, but I think those of us who grew up in law schools in the 90s really felt like we came into law schools where topics in the United States like torts or contracts or antitrust were fundamentally talked about through the lens of efficiency. And that was the result of the rise of law and economics. And efficiency meant something actually quite narrow and sometimes different in these different fields. Fascinating. It's a moving target, but broadly, it's a gestalt being borrowed from neoclassical economics that is insisting that efficiency is some kind of a neutral value that can commensurate and be technically managed so that we can make markets if we free them, work to the advantage of all. But it comes with a skepticism, and here I'll make a list of sort of critiques of that orientation, and I think you'll see the flip side of them are critiques that LPE project and scholars are trying to make. So one, a sort of skepticism in these kinds of courses towards antitrust, I would say intellectual property, which I teach. Skepticism that there's something like power in the economy, a sort of optimism that competition will kind of intercede on any forms of excess profits or power, for example, power over workers or monopoly power will be competed away with a very minimal role for the state to sort of, in fact, establish things like property rights, clear rules so that transactions can proceed and so forth. A very clear mandate, which is very central to law and economics in the United States, to maximize efficiency, and all questions of distribution have to be exiled to somewhere else, preferably a tax system, often in these conversations, but we don't think about distribution. We just think about maximizing efficiency. And then, of course, a sort of a deep critique of the state implicitly, that the state is bureaucratic and monopolistic, and that we need, and you see this also in public law classes, administrative law, civil procedure, that you need a kind of almost a market rationalization of the state. You need expertise-driven projects like cost-benefit analysis to rationalize the administrative state. You need managerialism to make the courts more efficient. And fundamentally part of this, and this connects to the conception of neoliberalism I was offering earlier, a real a background skepticism of democracy itself as a project, and a sort of a hope and a wish that markets could reorder our politics in some fundamental way. And so people then, as I'm describing the world into law school to which I came, interested in power and social justice, often were sort of segregated into parts of the law like anti-discrimination law. But for complex reasons, I think even those areas of law, which were not directly the object of much successful law and economics theorizing, really still came to reflect the sort of general sensibility, sort of what I would say a neoliberal sensibility about markets and how they work in the state and how it works and what we could expect from our politics. So I think you see a retreat even in these so-called public areas of law from any structural conception of how the economy interacts with politics. So I'm thinking back to my anti-discrimination law course, actually, I can't think of a time where unions were discussed. Labor law as a field denigrated deeply in this period of American legal thought, I think. And really a segmentation, courses like banking and corporations were taught by banker surrogates, sort of people who are interested in banking, but often with an economic bent or with practical experience, but not thinking perhaps or prominently in their scholarship about questions like what is money, what are banks, why should we have them? What role does the state have in this process? And so coming into that world, and then given the crisis that we have around us, I think what LPE is doing is trying to kind of unearth this architecture that of legal thought into which many of us felt like we were born, and critiquing it. And so, if I were to give you a very brief version of what I think some of the claims of LPE are, I would say it's a critique of the idea that the economy and political life are separate, that markets follow their own rules and in some sense can be left alone or should be left alone. Hence, the formation of political and economy together. Of course, by that, we don't mean the conventional meaning in some, say neoclassical economics departments, which would be the application of rational choice rules to politics or sort of thinking to politics. Instead, we mean the classical conception that we have to think about the political constitution, reckon with the political constitution of the economy, and then the implications of the economy as it constitutes our politics. And so we are thinking and sort of debating and trying to bring back terms like capitalism, terms like neoliberalism that will help us think structurally about what our political economic order is, how to think about how it's constituted, and then what its relationship is, in fact, to our political order and democracy, and how we might begin to express and formulate a political program that, in fact, brings democracy and our economy closer together, that democratizes our economy, you might say, in part to democratize our politics. So I would say, Katharina also mentioned sort of what are the intellectual antecedents of the movement. I would say very much legal realism, critical legal studies, critical race theory, and critical feminist work are all quite central, I think, to, and the work that we very much are drawing upon. That I think is probably lots more to say about some of the similarities and perhaps differences between these movements. I think also, though, of the law and political economy crowd as very interdisciplinary in its interests. So I teach Polanyi, and I think many other people are reading, whether in the varieties of capitalism literature or the sociology of the economy and sort of economic sociology literature, political science, and which I think itself is becoming more interested in political economy questions, certainly economics, of course. And I know one thing we're going to want to talk about is what's the relationship between economics and this sort of frameworks of law and political economy. I guess I'll say just maybe a few more things about some of the critical moves that I think people interested in law and political economy are making, and then I'll stop. So I think a couple of things that, well, what are we trying to do? What are our aims and goals? I think in an intellectual sense, there are a number of critiques that people are kind of building on and articulating in many different fields. So critiquing the idea of efficiency as neutral, but instead asking about how the kind of conventional ways of thinking in neoclassical terms about the economy and how it works have in fact helped to concentrate power, to support inequality, to disable forms that historically might have in fact better distributed economic power, or enable different kinds of management of the economy. A critique of the sort of idea that the economy is separate, and sort of things like distribution could be just moved later. And so a thought that we have to think together, politics and the economy, and embed equality into our economic institutions, as opposed to imagining that there's a sort of magical process afterwards where taxes and so forth generate equality after the fact. So many people, I think, are arguing for and thinking about how in different fields you could instantiate a primary commitment to widely distributed and less concentrated political and economic power as a matter of a kind of instantiation of democratic values. And then thinking also about ways to reform law in ways that make it more democratic and egalitarian, and that can confront some of the crises that we're talking about. So Katharina's work I think of as a wonderful example of this, thinking about how within corporate law or the law of arbitration, we have constituted the freedom that certain kinds of owners of capital have to impose risk upon others and to govern in certain ways, and then how you might challenge that, right? So these are fundamentally legal projects, and it's the last point I guess I'll make, which is that, of course, the law is very important in the law and political economy, and a lot of what we're trying to do is in our separate legal fields, but in ways that are connected by some of these frameworks of thought, as I'm describing, and disciplines that we're engaged with, is trying to understand how in our individual field, so for me, say, intellectual property, it would be an important one, how over the past several decades, ideas in this law, what is a trade secret, for example, have changed and been influenced by the rise of neoliberal ideas in law and economics, how they could change again, in fact, to better protect both equality and democracy, and as well as values integral to them, like a climate that actually sustains human life, gender equality, racial justice, and so forth. So that was probably very rapid, but I hope is a useful way to set the stage for our conversation.
Yeah, thank you, Amy. It really gives us a flavor of LPE from many different directions. So I'm just going to hand over to Nicholas right now for his introductory remarks, just to put this into his own perspective, and then we'll go to a back and forth between all of us. Nicholas, please.
Thank you. Thank you very much for inviting me to be part of this panel. I have a few points I would like to make with respect to the economic side of this. So in some sense, I'm directing my comments more towards the economists and how economists might want to look at their role to help this project along. I certainly encourage what's going on. I support what's going on. And I'm grateful that you're doing this, to think of a different way of studying the interrelationships between law and the economy, different than the Chicago School. I think my first point is any endeavor or initiative that helps move young, progressive-minded law faculty, economics faculty, or students, and ultimately practitioners in government and those on the bench, away from what I see as firmly implanted received paradigm of Chicago law and economics, probably is not going to happen without there being some fundamental shift in economic thinking. All right, this can take two forms. The strong form, I guess, would be a true paradigm shift created away from neoclassical economics. To me, this seems unlikely. We can always hope. I think more likely will be a weaker form, suggesting consequential revisions to the existing paradigm. So practically, and I'm glad to say this, I think no matter what sympathetic economists out there in this audience decide to do, as you can hear from Amy, and I'm sure others, the law is going to move forward with this endeavor, and that is to their credit. You already know what they've established: the association, the journal, the project. That's a good foundation. That recognized, and this is open for discussion in our session, I think the road they are traveling will be made much smoother, having an articulated alternative economic paradigm that can serve as part of the foundation of LPE. So the question I want to pose to the economists out there who are in various fields, subdisciplines of law and economics in the short run: what do you envision as the role of the economists in this undertaking? How do the various sympathetic economists, hopefully from those of you out there from institutional economics or new institutional economists, or from evolutionary economics, or advocates of comparative institutional economics, even the old New Haven school, even disgruntled, disappointed, and perhaps bored neoclassical economists, and others I may have unintentionally looking at. How do you bring these ideas together? I make the point here to adopt a phrase used by the libertarian author, social critic, and founder and editor of the conservative weekly magazine, The Freedom. This was Albert J. Noack, who, when in a similar position post-World War II, when there was at best a paucity of conservative economic thinking going on in the United States. In his famous book, The Memoirs of a Superfluous Man, he posed the question, how do we assemble the remnant? And this is what I look at in terms of how do we put together these various individuals who are interested in various approaches to the, quote, interrelations between law and economics, and integrate them into something that is comparable and competitive with Chicago law and economics. I say this in the sense, or ask it in the sense of how do we get the ideas of the relevant legal economic subdisciplines integrated into a coherent, progressive economic theory that provides LPE an economic theory in a workable format that can easily be transmitted to other faculty and students, but most important, to the next generation of LPE students. If we don't have something to give them, as one generation after another of Chicago gave to their people interested in law and economics, it's going to make the task much more difficult. I think it will be extremely difficult to move forward if we try to move piecemeal, by which I mean to ask some potential participant of LPE to accept some LPE Proposition 1 that emerges from a particular economist that provides theoretical support for Proposition 1, but then have to move on and looking at asking them to accept Proposition 2 that emerges from a different economist that provides theoretical support for Proposition 2. Again, part of the success of the Chicago School of Law and Economics is that all the interested participants were generally on the same neoclassical page. They all walked through the door with that common economic foundation. We did not need to go back and teach them about each economist's theory to learn about the LPE proposition upon which it was based. We all recognize there are a variety of existing perspectives and legal economic subdisciplines, some originating from the early contributions of people like Commons, Hale, Samuels and Schmid, Bromley, Neil Commissar was important, Oliver Williamson, Calabresi, Guido, of course, and many others. And hopefully some of you sitting out there who have both productive ideas from the current literature within the subdiscipline that you are involved with, and two, have a desire to move forward with the LPE project. So in short, we need to think about the best strategy to bring the ideas of the various contributing economists together in an effort to provide a coherent alternative or neoclassical modified economic theories. But for the economists out there, again, keeping in mind, this is for me, it's not about economics, but it's to recognize that the task before us is come together to bring a set of ideas, a theory, to stand alongside of and support of LPE law faculty and law students and association members to help LPE move forward. For me, that would be our purpose. You are, as economists, all here to speak for yourselves. In that sense, on the economic side of this, this is ultimately your show. Finally, the end game is to find a way to construct an economic theory that engages with LPE. We need a theory that avoids efficiency mongering, a theory that avoids any reference to something trickling down, a theory that avoids hiding the place of political power and market power in the allocation and distribution of resources in society. And most important, we need a theory that avoids creating another narrative that ignores or conceals much of what is important. We do not need another theory that operates without any critical awareness of unfair or unjust outcomes. What is needed is an economic approach that ultimately describes the real determinants of the nation's economic performance, defining the latter with respect to opportunity, some considerations of efficiency, but with a sharp focus on fairness and justice, and the enhancement of the character and quality of civil and economic life for the citizens of the nation. I'll leave it at that. I have other points to make on different aspects.
Thank you so much. So we, of course, also want to hear from the economists out there who associate with what Nicholas just said. I will hand this over to Amy, but let me just make just a brief comment. My experience, especially with economists in these kinds of conversations, has been that even those who sympathize with what you just said and what Amy said, basically will tell you that they can't get out of the system that they're in. They have to compete with other schools in attracting students. They have to publish, and you publish under a system that is deeply entrenched. And you made the point at the beginning. So one of the challenges that we face, we can have these pointillistic conversations about certain issues with good economists, but the much more sweeping transformation of the economic thinking and the academic economic profession, not to speak about the practitioners yet, is a huge challenge. Amy, back to you.
So that was very interesting. And I think, there's be wonderful to have a sort of deeply rethought economics that achieved, and I think you're even trying to be more modest, Nicholas, in what you're suggesting than a full rethink, but even just a substantial renovation would be wonderful. And I think you're right that there's a real value in and a skill in crafting those ideas and communicating them in a way that can be picked up in other fields. And I think, part of the success of law and economics was doing some of that, and neoclassical also and those ideas don't even always make sense, right? But they appear to, and that's important to that enterprise. I think, just maybe to say, one of the things going on among law and political economy, kind of, I guess, the crowd, I'll just call them, is people are reading and trying to educate themselves. There's been, reading groups on heterodox economics. There have been events with the INET, there's lots of events with INET kinds of groups, but also with the Economists for Inclusive Prosperity, who I think are also thinking about paradigms beyond neoliberalism and struggling with these questions, as Katharina said. How much can you really reject of the basic? And I think there are deep challenges here. I mean, I think one of the things that I stumble upon when I'm working on these questions, the question of the role of economics in law and political economy, is, on the one hand, obviously there has to be a role for economics. It's in the name, and we are concerned with questions which require us to think through issues about, if we want, employment, how can we best organize society such that we have something close to full employment? And those are questions that economists have thought very deeply about. That said, I think there are many categories and paradigms in economics which rely upon a legal order that is in fact deeply fungible. And I think about, again, Katharina's work here, or my own, that you can't just sort of build a set of assumptions about markets and how they work as if there were some clear and predetermined kind of law in the background. Law is constantly changing, and the question of what it means to have a property right in an area of financialization is actually very different than what it meant to have a property right in a different era. And these legal categories are constantly in motion. And so if you take the sort of legal realists and critical legal theories seriously about the legal kind of the legal architecture of markets, it becomes very difficult to think about what models in economics can correspond to that insight. It has a very powerful, I think, potential to dissolve the ability to think with some of these categories, or at least demand a different way of working with them. So that's just one reaction to this challenge, and one of the ways that I think at the juncture between law and economics, there are some interesting puzzles to try to work out.
So I think this was an interesting just arch to thinking about both the intellectual roots of LPE, but also the institutionalism and legal institutionalism of which Nicholas has been a part, also harkens back to the realists and the old institutional economists of the 1920s. So maybe I can just bring in David at this point just to think a little bit more about is there anything really new in what LPE has to offer from someone who has sort of studied sort of the history of thoughts about institutions in particular from an economic perspective, but also very often reached out to the legal literature and is quite familiar with those. So David, do you want to just give us a little bit of a background spiel, and then I go back to Nicholas?
Yeah, thanks, Katharina, for giving me a couple of minutes. I'd just like to kind of bounce off what people have been saying. So Amy just mentioned that groups of people within LP are engaging with various kind of heterodox approaches in economics, with INET, some with modern monetary theory and other kinds of relevant economics, which is not efficiency obsessed. And I think that one area of economics which is very fruitful for the LP crowd, again, to use the word that was used earlier, is this institutional law and economics, the legal institutionalism that Nicholas Mercuro was involved in. I mean, one thing which struck me when I first read the Yale Law Journal Manifesto was how much of it was I'd already seen, basically. I'm not saying that it's not original, not at all. I'm just saying that it was just striking that there was this very strong resemblance between both the objectives and the content of the project, at least as expressed in that manifesto, and the kinds of things that Warren Samuels, Alan Schmidt, who were both Nick's mentors, developed in the 70s and 80s. And Schmidt and Samuels, the institutional law and economics, or we can call legal institutionalism, they sought to establish an alternative to the neoclassically oriented economic analysis of law associated with Chicago. Interestingly, they sought to engage with these people as well, including also engaging with James Buchanan, key figures of the public choice movement in Virginia. So they were trying to reach out to various people at the time, at this formative stage of the law and economics movement. And as Samuel saw it, institutional law and economics was basically an application, as Nick already intimated, various insights that we can take from a long tradition from Thorstein Veblen, Walton Hamilton, John R. Cummins, Robert Lee Hale, and other institutionalists, and applying these insights to what Samuels termed the legal economic nexus, which broadly can be defined very loosely as kind of a dynamic interactions between economic, legal, and political phenomena. And it's very interesting to examine this, particularly in kind of within the broad interest that we all have, that we all share in the interrelationship between law and political economy. Because if you look at the literature produced by Samuel, Schmidt, and others in the 70s and 80s, you can find that they don't see the economy as a separate domain. They don't see efficiency as something completely neutral, axiologically neutral. They don't see prices, costs, income as natural concepts. They don't take efficiency as the ultimate metric, or even an appropriate metric, or to the exclusion of others. They associate rights with social positions, social structures, and power, and not just market power, even though obviously that's important, but also with the constitutive power of law and with political power. In essence, legal institutionalism always acknowledged that the legal assignment of rights can lead to deeply unequal social, economic, and political relations. And as I see it, and as clearly Amy suggested earlier, these are the basic building blocks of the LP project. There's a shared motivation behind both projects, analytical and political projects. There are, of course, differences, and I'm not going to go into those, but because there's so much in common between the legal institutionalist work of Samuels and others, it's kind of surprising, at least I'm kind of surprised that the LP scholars don't really make much more use of that literature. Here is a heterodox economics with people trained in law and willing to engage with law and lawyers and judges and so on, commenting on Supreme Court cases, just like normal lawyers would do in academia, doing the same things and sharing the same objectives. And so they seem to me much more, their project seems to be much more germane than for example, some aspects of heterodox economics that were mentioned before to the LP projects. Not to diminish the importance of those other projects of heterodox economics, but this one seems to be particularly germane to LP. Yet, as even Amy mentioned earlier, it's kind of absent in the genealogy of LP as defined by its own proponents. So you mentioned earlier the realists, then you kind of skip to critical legal studies and critical race theory and so on. But in the middle, I mean, there should be ILE in there. So institutional law and economics kind of ought to be there, at least in my view. And I think there's two reasons for this state of affairs. One, of course, is that the institutional law and economics was produced by relatively marginalized economists with relatively few connections in top law schools, and certainly very few followers in those top law schools. Second, I suppose, is that that the few economists sought to advance institutional law and economics after Samuels and Schmidt retired. They kind of withered out. There were still people, but they weren't in any sense a critical mass, producing the kind of textbooks and journal articles and conferences to engage, to create a momentum behind these ideas. And of course, this raises a whole issue of questions, which I think we've all touched upon, and to which we'll come back in a few minutes. But I suppose for me, I guess the vital question here is that why did institutional law and economics fail to establish itself as a viable alternative to the economic analysis of law? And I've kind of suggested part of the answers to this, and Nick has suggested part, and we've kind of all suggested this, but probably we want to discuss that a bit more. And I think the most important question, really, in the context of this panel, is what can LP learn from this failure?
That's, I think, exactly the question that I wanted to bounce back to Nicholas. So, either based on your own experience of not having been able to really galvanize enough people to make this a full-blown movement, but also, as you suggested in your introductory remarks, there is now a moment. There is actually a movement, and there's actually quite some power behind it, and it's at the top law schools in this country, and it's mushrooming, as I said earlier. What is it that we can learn from this earlier? I don't want to say failure, but lack of success in really mustering an alternative to the Chicago school, to what's happening right now. Nicholas.
2 points. First, with respect to what David said, let me quickly explain. I was going to make these remarks earlier, but I'm glad it follows on here. What really frustrated Warren that was going on in neoclassical economics was this ubiquitous phrasing and titles used to describe undertakings that were trying to describe the interrelations between law and economics, or between the interrelations between legal and economic processes. What got him to the legal economic nexus was that every title, including yours, is what was driving him crazy. It's law and political economy. Well, political, to a certain extent, implies law. Al Schmid once wrote an article. He was part of us, right? And he wrote, why do you call it institutional law and economics? It's redundant. Institutional economics is that interrelation. And there was never a phrase, and then Warren would talk about the books, the economy and the polity, the private sector and the public sector, the economy and government, the state and the economy, government and business, law, politics, and economy. This phrasing implies the separation. And so does law and political economy to a certain extent. But of course, the way it has evolved, and when you understand what you're saying, I think this is what David's point is, we had already done this with the concept, or Warren had done it, with the concept of the legal economic nexus, that the economy is evolving, law is constantly evolving. But to understand the performance of the economy, you have to understand there is not a separate thing called law and a separate thing called the economy. They are constantly interacting, that the economy is a function of the law, and at the same time, the law is a function of the economy. And you cannot just stop and say, what neoclassical economics does, is to say, we have a change in law, this separate thing here. Let's look at the change in this separate thing we call the economy. They are constantly interacting, but we don't have a name for that interaction. One of the reasons, going back to why it never got off the ground, that is very anti-neoclassical, to say that the economy and the law are function, because then you would not say, as economists would when they teach blackboard economics, these firms are price takers. Well, for an institutionalist, we would think of it, these firms are rights takers. that implies something much different than being price takers. And so you get this idea of the legal economic nexus as this constant evolving law and economy, and therefore every outcome is temporary, because also within the system, there is the role of government, which is much different than neoclassical version. It's constantly there, it's pervasive, it's always handing out political power. That political power is used in the context of the legal economic nexus to get the outcome you want. So all of these temporary, quote, efficient outcomes are a function of the past legal economic interrelations that were going on that produced these temporary outcomes.
So I'm going to hand it back to Amy and to respond to this, but maybe also just add on top of this again, why do you think that this movement now came out of a law school, and what is the importance of that? I think the two things are linked, and then we will open it to discussions. I already see the first hands coming up, but Amy first.
Yeah. I mean, I think one way to think about why any intellectual kind of initiative succeeds and or sort of remains just a resource for the future has to do with the surrounding environment. And so there's no doubt, and the reason I started with the kind of level of crisis that we're in today, I think, and climate, race, democracy, I mean, is that it has created, I think, sort of forms of disjuncture and also forms of anxiety that that make it important to people in many places to come up with new theories, and that make some of the challenges, some of the weaknesses of the old theories and their partiality and failures of the neoclassical paradigm and the neoliberal paradigm really obvious. And so some of it, the world around us has changed, and people are more eager for new paradigms and questions than I think probably they were in previous periods. And there's a political economy story there too. But I guess maybe the other thing that's running through my mind as we're discussing this is that in my thinking about political economy, part of what's so important about that framing is that it brings us back to people who really did have a much more capacious understanding of political economy as a moral science, as a place where we debated values, not because you needed a value as an input to some models, or, right, for institutional design, but because that was part of what political economy meant, was thinking about the kind of equality that one could expect out of economic order, and what was good or bad about that. Was the economy moral? Could it be moral? That's what people like Smith and Marx were talking about. And I think we're very keen to reclaim the importance of reasoning about politics, democracy, racial justice, gender, that has happened far outside the realms of economics, of any economics, even the most heterodox and the most, because those questions were screened out for many, many years. And so, it's not easy even to meld a certain kind of economics with, or use a certain kind of economics, even a re-envision form, to think about all the things we have to think about in political economy. For example, I think the role of the carceral state in the way that class politics in the United States work out. So there's just all kinds of questions that I think are hard to get to from within sort of economic reasoning, including from within rational actor models. And of course, some of what's happening in the world of economic sociology, and I know for some institutionalists too, is an attempt to sort of think beyond rational actor models and think more sociologically, more about categories like ideology even than is acceptable within narrower forms of economic thinking. And so I think I'm trying to also hold on to the question of what a new sort of reformed economics could, how it would sit with the questions that are also running through political economy conversations about how we should presume subjects act, what a subject even is, and sort of some deep skepticism about how helpful a sort of stripped down rational actor kind of foundation would be to think about that and so forth. And so the questions run very, very deep, and part of what makes it so interesting.
Great, thank you. So, yeah.
If I just may quickly.
Briefly.
Part of the burden on economics is when they understand what LPE is trying to do, is to make that transition as smooth and acceptable as possible. I know that's a tall task, but I think there's no reason for us to move forward with building some kind of altered vision if we can't put it in terms that could be sold. Remember the antitrust students in Chicago Law School. In retrospect, they all said, the reason we bought into it is because it was so easy to understand, right? Bork finally fed them what they wanted, right? You could understand consumer welfare, and now we've got it. And I think that's part of the burden on the economists in trying to build a structure. It's one that recognizes what's going on and what LPE is trying to do. And the challenge would be, can we do that? I'm as skeptical as you, but I don't know also what's going on out there. And my hope would be is, 20 hands raised and say, I have an answer. And I could do a volume in my book series on putting them, we'll publish a book together. But what really causes success, which I think was the question you raised earlier. Institutionally, and why law schools? Chicago was always open to this. Do you know the story, the early story of when Chicago started? It didn't have a law dean. And the president had to go out and get a law dean. And he got Joseph Beale. All right. And you would figure, well, here's the ultimate Langdellian, right? Joseph Beale from the true doctrinalist. And Joseph Beale said, I would not consider doing this because Ernst Freund was there. And he always insisted that as part of the new law school at Chicago, the social scientists had to be incorporated. And you can go read the manuscript or the comment or the letter, basically Beale wrote. He said, I would not take this position. And by the way, this was a 2-year interim position. He was kind of like the start off for the law school. And they thought they would get someone good. And he wrote back and said, I will not take this position. I know he's there and what he's trying to do. And unless the only faculty you teach are faculty who have law degrees, and that the only course content is law, I will not accept the position. So somehow he and the president worked out and he came to the law school for 2 years. He left, Freud kept it down. 2 months later, Freud started inviting philosophers, economists to jointly teach law schools. They immediately, as soon as Beale left, started going on down the road to integrate law. That's why institutionally you don't have that in colleges of social science, incentive structures for economics departments to do this. Whereas in law schools, it was always an open arrangement. I'm not saying law and economics is exclusively neoclassical. I mean, there are a lot of courses that go in a lot of different directions, but so you need that institutional acceptance. The other thing you need, of course, I won't repeat, is a paradigm. And the other two marks of success, which we didn't have, were the people, enough people, all right? And Chicago had them. Now, interestingly, in the first Chicago school, they were very tangential. You could not, and by 1946, what was left of the University of the Chicago School of Economics, you could not describe it as a bastion of conservatism. Frank Knight had already left because of the direction economics was going. It was basically Henry Simons, and he passed away by 1946. Veblen was gone.
Yeah.
The institutionalists were all gone. All right.
So
Cowell's Foundation was there. That was full of a bunch of self-identified socialists. Oscar Lange was there. He was a socialist. So by 1946, the school was over. When what we know of today as the Chicago School, I tell my students it's Chicago too. It starts in 1946 when Simons, Hayek brought director back to the law school, not to the economics department. It was director then in the law school that created everything we know of as the Chicago School of Economics. He was the impetus ultimately to get Stigler. And then it went through the economics department, it went through the College of Business, right? It became a three-part moving hand of what we know today with Stigler and Friedman and all the others. They were after that first Chicago school. They really started in 46.
So
And
looking
then
at
Posner,
the
Posner and the others jumped on board later.
So like looking at the history of the movement as such and where it's institutionalized and how seems to be also a really important aspect.
And the money, finally, the money.
Of course.
There was no Olin's
Yeah.
Institute. In today's dollars, they gave about six or 700 million to put in those 10 or 12 law and economics institutes at the law school.
There's there's some counterweight to this today. So there's some foundations are coming on board and realizing the need for finance. So I have a couple of hands already up. As I said before, please be on note that this is recorded. So your questions will be recorded as well. We would like you to show your video and ask the question, but if you feel uncomfortable with that, that's fine too. Please keep your questions succinct because more might be coming up. I will group two and give it back to the panelists and then go back to the order in which I received the questions. I have Eric Scorzone first. Eric, can you hear us? Yes.
I can, yes. Hi. Just two quick comments. I did work with Al Schmidt, Warren Samuels. I think I would say this. I mean, they absolutely have a lot in common with what Amy and the LP groups are doing. I've sat in through most of the appeal sessions over the last year. I think the challenge is that institutional economics doesn't have a textbook because it has so many different theories, and there's really no consensus on, like, say, the theory of consumer behavior among institutionalists, or the theory of the firm. There's probably half a dozen theories of the firm, and they're all very contextual. So I think the real challenge will be, if we're talking about the simplicity and the need to teach students, the institutional, and I want to say institutionalists are very alive and well. We have two associations in the United States, AFEE and AFIT, and I just was at the conference for AFEE, and there's a lot of good work going on, and I would really encourage more interaction between the institutional economists, the heterodox, and the legal side, because I don't think there's enough of that going on, honestly. But we all have to probably struggle. I think Amy's critiques is right that we don't have probably enough thought through that enough. Even Al and Warren, I would argue, probably didn't take it to those areas. I mean, their work was very foundational, but at the end of the day, it didn't sort of provide us with, one little simple theory of the consumer. And so I think that's where, and even modern monetary theory, which is very popular now, that's macro level. I mean, that isn't giving you really a micro level theory at this point. So I do think if we're going to be successful in econ, especially, we're going to have to figure out, do we have one theory? Do we have four theories? How do we teach those theories to students? Because I think that's where heterodox has really struggled to get any traction, is we just don't have a coherent way of doing it.
Thank you very much. Matthias Goldmann. Are you still there? Oops.
Can you hear me now? Sorry,
Yes,
sorry about that. So
Yes.
I suppose my question is very similar to Eric's. Just from a legal perspective, I also wonder, it bothers me, why was law and economics so successful? What can we learn for law and political economy from that? And one factor that I suppose, or that I suspect to be crucial, is really this technicity, this rationality, this calculability that is kind of inbuilt in law and economics, and that is also, familiar to economics as such, the idea of equilibria, etc. And you can really show something that seems to have a great usability to policymakers, and that is kind of that has a technocratic appeal. So I wonder whether it would be possible to make law and political economy successful, which I very much hope for normative reasons, without a major epistemological shift. And well, what do you think about that?
Okay. Shall we start with Nicholas for this time around? Do you want to respond?
Without an epistemological shift, sounds like you're just going to extend what's there. I mean, without moving away from, and as Eric just said, we're not certain as to what to, but without moving away from the neoclassical paradigm, and I mean, I guess you could say, let's relax the rational choice. But a lot of economists, I mean, Buchanan was all not, and public choice theory was not that enamored with rational choice. It was Tullock who brought the hard-nosed approach. And he wasn't even the economist, he was the lawyer. But he brought that approach in. I just don't see how you can do it without changing the foundational paradigm. If we just go back to LP&E and say, look, live with the paradigm, I don't think they would or should accept it. I mean, I would rather see them go and draw from here and draw from there and draw from here, draw from there and move forward. But the paradigm is so strong and it's ideologically, entrenched, and with that, you end up with, like I said, they had $600 or $700 million building those institutes. Feminist jurisprudence never got a check for $600 or $700 million. I mean, this is that it's even considered a competition. It was simply a buyout. And when you read Tellus's book, the buyout was straightforward. The foundation simply said, listen, we're supporting this guy, Henry Manning. I think at that time when they were giving the money out, he was at Emory. And they said, Emory's not a bad school, but most of the directors on the board at Olin Foundation, these were all Ivy League people. They said, let's do this in the right place. So they went to Harvard, Yale, Columbia, Stanford, Berkeley, Duke, Georgetown, and Michigan. And they put in 12 institutes. And these were institutes where the departments of economics were supreme and the law school was supreme. And they were able to offer them 5, 6, 7 new faculty members. Every dean, every memo he reproduces from a provost is the provost saying, I'm not interested in this, but I can't turn it down. And that is really, what happened. And George Mason was no different, except they didn't get money directly from Olin. That was more Koch money.
This is capitalist academia.
Yeah, it is. People like Fink, when you name, you need people to move this forward. And I had listed some of the names of people who were probably the best salespeople for Chicago. Certainly Henry Simons and Hayek, although Hayek was always at the margin. He never really got paid by the University of Chicago. Lunow always paid him through the Volcker Foundation. But they were the ones responsible over a long period of time of stopping and going and stopping and going. And then with Simon's suicide, and still in 1946, they get director to the law school. Henry Manning, say what you want, but he sold a program on educating judges on Chicago neoclassical economics. And he then sold economists on the idea of learning the law in that interconnection. He was someone you cannot say, look, he was an entrepreneur. Jim Buchanan, albeit he had trouble at every Virginia university he started at, and ultimately he walked away from the last Virginia university, George Mason, where he ended up at.
Can I jump in, Nicholas?
Sure, please.
I was going to say, I think we have these debates, right? Like, what was the nature of the success of law and economics, and how much does the sort of technical aspect of it matter? And I think we shouldn't necessarily, first of all, attribute too much technicity to law and economics, right? I mean, there's an enormous amount of fuzziness, actually. And I think maybe more work is being done by a set of mid-level assumptions that are just assumptions, like competition works is going to work well and compete away. And it's not a technical move so much as a set of mid-level assumptions about how the world works that fit together ideas about what people are and how they act. And so I think that paradigm, I think a different paradigm is important. And Nicholas mentioned this too. And how much sort of the technical is beneficial might depend also on your vision of what you're aiming at. So I like to think that the part of why training judges and the appearance of something technical that only somebody with a PhD in something could address worked for a certain kind of political project is that it confines who can participate in that project, and it has a certain politics embedded in it, right? And I'm not sure my own. One of the questions I'm interested in, and many people at LPE are thinking about, is how do you democratize the administrative state, right? And so not just allocate questions to a bunch of experts, but think about how, in fact, including in governing complex issues like healthcare or the economy, how do we think about democratic accountability in those structures? And that's because we have a different goal than I think some of the people who chose another set of methods. And I think the goals and the methods interrelate. And so I'm skeptical in too much investment in an idea of either training judges or technical, like sort of the way that law and economics and the Federalist Society did it, because I think their goals were very much tied together with those methods. And I think my own goals, and not everybody has the same goals who's interested in political economy or LPE, but my own goals, I think, are not likely to really mesh so nicely with that way of proceeding, even if it's certainly one way to be effective as an academic movement. I do think, though, there are lots of other academic movements that don't pretend to that kind of thing. You still have to be systematized. You still need paradigms. You still need foundations, right? And so, but those could come, there are many different kinds of that. And I guess that's a little bit where I tend to go. Mm-hmm. Sorry, we've gone on too long, but probably an answer to your question.
So I'm going to call on two more people from the audience. I have Neil Anders first, and then Arbor Rupert, and then I'll hand it back to you. If you have questions, please raise your hand. We'll try to do at least one more round. So I think we can get this if we all are succinct. So I have here Neil first.
Hello. Thanks for.
You just muted yourself. You have to unmute yourself now. You were fine first.
Okay, let's try that again. Okay. Yeah, I think possibly one of the issues of maybe what might call sort of self-sabotage would be the sort of the whether or not the target was redressing inequality or whether or not it was in a general sense, and actually how one actually really sort of defines that. And I certainly kind of think of obviously when Piketty actually released the book and how seminal that was to the conversation. But even once Piketty actually sort of put the book out, there were sort of questions as to how you actually value real estate and whether or not you could actually reduce the whole project down to the particular formula that obviously the book was often seen as summarizing. And then, sort of how you sort of base that against maybe a general project, particularly in the States, of injustice versus inequality, whether or not actually injustice was actually something that was exactly the same, and to what extent they actually overlapped. And I think that the discontinuity within that argument allowed opponents of both to basically come in and actually say, you know what, we're actually just more efficient in doing what we do. And I think the efficiency within on the other side of the table was quite simple, which was actually to raise money and make sure that it has the least amount of regulation, the most amount of protection, and the most amount of leverage. And I think that's actually a fairly, you don't have to necessarily be a banker. You could be a technologist. You could actually be someone in crypto. And I'll come back to crypto in a second, but however one defines oneself.
Keep it a little shorter, right?
Yeah. I'm sorry. I think my point is just very quickly. Yesterday we obviously saw some new Fed appointments come out, which I think there's a lot of hope for that. And I think there's also a lot of hope for kind of repurposing, if you like, the Fed and central banking in general for more climate friendly projects. So I think my point is that instead of actually sort of looking at, even though academia is incredibly important, and there are lots of things within academia and within the academic sphere that are extremely important, that it's in terms of breaking out and in terms of actually what success looks like, is probably just some very, very large scale initiatives that you actually raise intellectual and financial capital for, and that you actually break that out of the academic sphere.
Thank you. And sorry for interrupting earlier. I just want to make sure we can get everybody in. Arpa Rupert is next, and then we'll go back to the panelists. And I have two more, so we'll try to do a final round. Keep this in mind as you answer.
Yes, ma'am. Dr. Mercuro, good to see you again. I think the success of the LPE, can I be heard? I think the success of the LPE movement will depend on, from what I'm hearing, and I read the manifesto, two main things. One, how will its main proponents deal with their own sacred cows? I have 20 years in academia, both in law and economics, separate, not law and economics together, but law and then economics. And I have never found, and I hope you'll forgive me, I've never found a bunch of people with more sacred cows and areas of human life where they're unwilling to look. And two, I think its success will be determined by how well you deal with nature, how well its theories and how well its ideas comport with nature. And nature governs everything we do. I think it's vain to consider ourselves not animals. I think the theologians would say maybe we're more than that, but we're sort of a human creature, and we have rules that govern us. And LPE will, to its goals, if our goal is to fly, I have to comport with physics and its rules. In the manifesto.
So can I also ask you to keep it short that we get?
Absolutely. Mm-hmm. So there's a few phrases that suggest deep controversy with the express needs. We're never more networked in history than we are right now. We're talking to each other in unprecedented ways, and we don't want equality of outcome. We don't. I work with plebs. I'm not in the academy anymore. We don't want equality. So if you mean something more like we have more access to resources, address that. But we don't want, I have no desire to be or live like Bill Gates. He's a maniac, and he's driven like a man insane.
Okay, let's turn it back to let's turn it back to the panelists and get the other questionnaires. But thank you.
Well, how do you define capitalism? That was the main question. If we want equality, how are we defining capitalism?
So I'm happy to respond to that, since I wrote a book about capital and capitalism, but it's not my panel. So I'm going to hand it back to Amy and Nicholas first. Amy, you want to start this time?
Sure. Well, I mean, I think there is a very interesting issue about how you define capitalism, and we probably would run out of time if we tried to go into depth on it. But I would think I'm partial to thinking about it the way Ellen Wood does, as a system where everybody is dependent upon the profit motive, both those who labor and those who own capital, and as a system that is integrally based upon a legal order, which is something else that I think is very foundational to Ellen Wood's work. So beyond that, I would say you'd get a good sense of my understanding of it if you read Ellen Wood, I think. And then I think maybe I'll hand it off to somebody else so we don't run out of time.
So Nicholas, do you want to address maybe the first questionnaire as well, who said it's not only just an academic struggle? Maybe you're better off if you take your battles, I understood this correctly, out somewhere else.
Yeah, I think you're right. It is not just an academic struggle. But how far do you want that question to reach? Can you?
Yeah, it's very simple. Everyone all the way down into the blue collars workers with whom I work constantly. I have many clients. I have a few high net worth people, and most of them are blue collar. They have a keener sense of the financial world and its recent history than ever before in history. And I know this because I read all of the history and all of the historiography from all of the economic thinkers. If they're out there, I've read them. So there's things that we want, and it's mostly to be unregulated such that we can govern our own lives and make our own business arrangements and not have to deal with people from OSHA showing up and telling us we need to be vaccinated.
I know, but look, I listened to the libertarian debate, okay, for president. There were 5 candidates up there. And one of them set forth that argument because it's a very libertarian argument. And you have to stop listening at some point when one of the person I think who came in third for president candidate said, if I have a business, it's my responsibility to build a road for you to get there. It's not the state function. And at that point, I just say, you know what? We're just in 2 different worlds. And I had no other reason to listen to that person. All right, because that's the road you're walking down. You have a business, but you'll build a road for people to get there. When I say build the road, I mean pour the cement. All right. And
the McDonald's down my street did have to actually hire contractors to get there.
But the world can't operate like the McDonald's down your street.
Let me maybe make the general point as well, that a legal system, of course, including all the property rights and contracts, are a social resource as well. But I think what we should do is have a final round. We have 2 more questionnaires up there, and then we can go through the panel and respond to that. And then we were trying to close on time at 1:30. So I have Gautam Bhatia and then Leo Hennecke. Gautam?
Thank you. My question actually stems from what Amy said about democratizing administrative state. I was wondering in that context, what LP sees as the role of constitutional design in achieving its goals, especially because the Chicago School, of course, tried to write its economic theories into a constitution, the Chilean constitution. So in that context, I mean, what role does LP see as constitutional design playing in achieving those goals?
Thank you. And Leo?
Much. I wanted to touch on this issue, which was mentioned a little bit already, that capital has this tendency to draw upon the parts of theories or approaches which are useful for its processes and leave out the rest. And Amy, I read your paper on the law of informational capitalism, and I was very flashed by this part where you talked about how the proponents of the public sphere and the free data movement were actually contributing to the interests of surveillance capital, or at least not working against them. And because of that, I wonder which parts of the LPE approach or movement are in danger or of getting incorporated by the needs of capital, or maybe which parts satisfy the needs of capital and therefore need maybe to be more precise or more specified. Yeah, thank you.
Amy, do you want to take both first? The first
Yes, those are both really interesting questions. I think maybe, Gautam, to start with your question, I don't think there is a position about the role of constitutionalism. I think there's a, actually we just did a series on our blog with various people, me being one of them, proposing constitutional amendments to the US Constitution. And I think implicit in those pieces was the sense that the constitutionalism is going to shape the structure of your political economy and your democracy. And so a good constitution would shape it in a way that enables sort of deep form of democracy. So there's material, so for example, the amendment that I wrote charged Congress with providing for a democratic political economy, including through workers' rights, through protection of the environment, through protection of health, and the people's welfare and so forth. So empowering Congress in that particular way. And so I do think there's a strain of empowerment of sort of democratic empowerment, as opposed to, say, a more, I would say historically, the constitutionalism as it's come to me and many of us, I think, has been very focused on the judiciary and the sense of limitations, particularly vis-a-vis like the judiciary. That said, I think there's sort of lots of terrain that has not really been discussed and debated. There's a new book coming out by Forbath and Fishkin, where they're arguing for a sort of more positive constitutionalism, a claim of rights, for example, the right to work, that wouldn't necessarily be judicialized, but that could be essential to constitutionalism in this framework. The other question about, hold on a second, I've got to let my cat out and let somebody else come in, and then I'll come back to the last question because my cat's going to drive me crazy otherwise.
I really don't have, David, do you have anything on that question? I haven't done anything. Oh, there's.
Here we go. It was fast. You can continue.
I'll hear my cat. The other question about, are we at risk of taking on features of the kind of prevailing paradigms and therefore, and in fact, even strengthening them? And I think about that a lot. I think, of course, we are. I think that's inevitable in some sense, because, of course, you think in a context. I'm a structuralist fundamentally, and I think we are influenced by our structures and the disciplines that we are born into, and we perpetuate them in part without knowing we do. That said, I think one thing, and this actually connects up to Gautam's question, that I think many of us are thinking about is the role of democratic power building in transformations of the political economy. And so that fundamentally, if we are interested in shifting and having a more genuinely egalitarian political economy and democracy, that one has to think about that through the lens of power building. And so, naturally conversations, for example, about unions follow in the United States, and worker power, and conversations about abolition and decarceration. And to me, one reason that those are so important is because I think there are ways that, without opening up the conversation and the field of politics, there is an even more serious risk that you kind of simply fail to ever get enough power to make some of the kinds of changes, which of course will be deeply, deeply resisted. And part of that, part of the reason, for example, that all those arguments in intellectual property for openness didn't work was that I think they weren't based on a structural analysis of where firms like Google's power came from. And so part of the reason I think that we're also thinking in larger terms, like questions about capitalism, say, and power, are as a hopefully somewhat of a response to what happens if you simply try to take sort of one layer or problem and think about it by sort of inserting freedom into that layer or problem, but rather think more structurally about these things together. But I'm not sure that there is a solution to the problem that you're posing. The best one is, I think, being aware of it and mindful of it and thinking about elites' own roles in perpetuating kind of the current paradigms.
So I think, we're almost out of time, but let me just sort of try to, there was a lot of agreement here and a lot of support and mutual support, but I think there might be actually tension here. And I just want to put this on the table. Maybe we have just a minute to respond to that. I think there's a tension between Nicholas' aspiration to say the economists have to get on board and they have to provide you with a coherent theory, because only if you know how to teach the next generation and give them something to hang on to and to form their own thinking, even including in economics, in particular economics, can we actually have a longer term impact and does this whole thing really make sense also from a social science perspective? Amy, I read you mostly saying we want to be pragmatic, we want to be problem solvers, we want to also be very pluralistic in the different approaches that we sort of read and learn from and then integrate without necessarily, other than some fundamental values and some outcomes that we want to achieve, necessarily making a commitment to a particular theoretical or concept. So I'm not sure whether I misread the two of you, but maybe you could both briefly respond to that, which I think is two different directions, notwithstanding all the agreements that we've had. Nicholas, you want to go first?
Sure. Well, I think if the theory could be provided amenable to LPE and works for them, the road is much easier to have law and political economy move forward than without it. Because without it, you are simply going to have to keep going back and siloing people or ideas. And those silos will have to be learned by everyone who is interested in what you're engaged in. And again, I think that's, for better or for worse, that's how Chicago, one of the 5 variables as to why Chicago succeeded. Again, they were institutional acceptance. They had the money. They had the money. They had the support, the paradigm, and the people. And they were able to do it. I just think it would be an easier path with it than without it. And that's why I always said from the outset, we never wanted to have a debate, because I'm not debating you about that. I'm really trying to help.
Yeah, and I think I think of part of the project at the moment as opening up and reestablishing a sort of terrain of inquiry, like what are the kinds of questions we have to ask and put at the center of our work, and what kinds of resources might we draw upon. And but that's not to say that doesn't evolve into something that is more assertively a paradigm, for example. I think but I don't see that as the project of one person. And I think in moments of real intellectual disjuncture, it takes cohorts of people drawing on different kinds of resources. If you think about how neoliberalism was constructed, that was it, right? It actually was a project of decades and many different kinds of people who actually often deeply disagreed with one another, including about paradigmatic questions like what's the nature of a subject. And so I think new paradigms can emerge, and that there's real virtue to that. I don't think I think we're early on in that process. And so there may not be so much tension between us. I may be a little bit more open to the paradigm being shaped by many different disciplines than maybe a conversation that began in economics would start with. But I think there's actually is just a need for a tremendous, now many years of intellectual work to try to consolidate these new ways of thinking.
Great. Thank you very much. Thank you to both our panelists. That was really a wonderful, inspiring debate. Thank you, David, for joining us, also for bringing this into a broader conceptual perspective and historical thinking. And thanks to the audience for joining us, listening in and participating. We hope to do more events like this with WINIR, but for now, I just wish you a really nice Friday evening, afternoon, and a wonderful weekend, and I hope to see you soon.